Part Roman 2. Strategies for Issue Spotting Analysis and Argument. Heart, Brains, and Courage. Chapter 8. Taking Exams Seriously. A World Full of Wicked Witches. Part F's description of the multiple issues you may find buried in exams is merely one of many accounts of legal reasoning techniques available to law students and practicing attorneys. We have chosen to emphasize the way in which complex facts often present a set of decisions that lawyers and judges must make in considering how to resolve disputes. That's because this skill is heavily tested. What we want to stress with equal force in Part Roman 2 is that spotting issues is simply not enough, either to ensure good exam performance or to make yourself into a good laver. Your professors are looking for you to push through the ambiguities you find and testing your ability to analyze real-world disputes. Many people, we know ourselves included, spent a good deal of time in law school decrying the importance of grades and exams. No doubt legal education would be improved if students received more feedback and grades were based on multiple exercises rather than just one exam at the end of each course. We think there are reasons, however, even apart from mere professorial inertia, that the standard law school exam has changed very little over the last 50 years. Exploring those reasons may help you understand why we persist in putting you through all this torture. Consider the following story. You are an associate in a large Texas law firm, attending a meeting with several other associates and a senior partner, whom we'll call Carla. Carla has called you all together to listen to a problem presented by a longtime client, Fred, the owner of a medium-size real estate development company. Fred explains that he wants to launch a substantial excavation project in the remote Dallas suburbs. Fred tells you he plans to pump enormous quantities of water from beneath land he owns. He's afraid, however, that all this pumping may cause subsidence of neighboring lands, and that this might even cause damage to homes owned by the many suburban neighbors. Fred tells you that if he has to pay for this damage, the project will become economically infeasible. He wants advice on what to do. Notice first that this story sounds very much like something that could happen to you in law practice. It also looks very much like a law school exam question. This is no coincidence. It has become fashionable at today's law schools to criticize traditional law school classes for failing to incorporate the performance skills necessary for law practice. Thus, many schools have added required courses in negotiation, witness preparation, client counseling, trial practice, etc. We applaud these developments. From our vantage point, however, there remains a direct and important connection between actual lawyering and the skills tested on traditional law school exams. Indeed, one reason law school exams look so different from tests in other settings is that law exams reflect professors' efforts to get students to stop thinking like performers on quiz shows and start thinking like people whose knowledge can be brought to bear to help clients. Our story may help illuminate this difference, so let's get back to it. As you read on, notice how many of the participants in the discussion are responding to Carla, as if they were taking pages from a playbook written by undergraduates, the law school rumor mongers, or, if the truth be told, other guides to law school exams. See for yourself whether you find the comments of these associates fully responsive to the situation. The tall associate on your left, whom we'll call College Whiz, is the first to speak. It just so happens, Mr. Whiz pipes up, that I've been reading a great deal about water law. One thing I have learned is that the law draws a key distinction between underground water that runs in a clear path and percolating water whose course is hard to chart. Whiz grins from ear to ear, expecting a big dose of praise from Carla and the rest of the group. Instead, Carla turns to Fred and asks, "Can you tell us anything about the nature of the water under your land?" "Oh yeah," Fred replies. "I had a geologist out there just last week. It turns out that the water under my land just bubbles all over the place. No one can predict where it will be when, but there sure is a lot of it. I can make a bundle pumping it out and selling it to those big power companies." The next to speak is a rather quiet associate who seems to know so much about law that everyone has nicknamed him Encyclopedia. He begins inauspiciously. I think it's important that we all put Fred's problem in the context of the broader history of water law. This past week, I have read 3 books about the origins of riparian rights, the ways in which different communities have grown depending on what water laws they have chosen, and the need for water conservation. I thought I'd tell you all what these books have to say. 2 sentences later, Carla asks Encyclopedia to go get coffee, and Fred breathes an audible sigh of relief. A young woman associate, whom we'll call Miss Issue Spotter, chimes in next, thinking she's going to score big. I think it's pretty clear, she says, that Fred came here for help with whether he can pump out the water, and he's probably not interested in a long lecture about water law. Fred smiles, and the other associates nod gently in approval. Carla, however, is not impressed. That certainly is pretty clear, she says, casting a withering look over at Miss Issue Spotter. Your best friend at the firm, whose parents oddly named her Iraq, is the next to venture into the discussion. Issue Spotter is right, she says, that the issue is whether Fred can pump without paying for the damage. The rule in Texas is that, as long as you aren't intentionally and maliciously out to hurt your neighbors, you can pump as much percolating water from underneath your land as you would like. Applying that rule is simple because Fred is engaged in legitimate commercial activity. So the conclusion is plain that Fred can pump without paying for the damage. Iraq is so happy. She expects the meeting to be adjourned and a letter written for her promotion file. Carla asks, however, if anyone has anything else to add. I sure do, pipes up Mr. Real-world experience, an older associate whose stint with the firm began only after several years working for his dad's real estate company. I don't care what the legal rules are, he opines, for in the end some loose cannon judge is going to stick it to Fred because courts are going to favor smug suburbanites over risk-taking business folks every time. I agree, echoes Miss Policy. But it's not a matter of favoritism. It's a matter of weighing costs and benefits. Courts won't want to encourage development that damages the surrounding community, and so I'll bet they'll find a way to hold Fred responsible. Carla turns to Fred and adds the following. I think what my colleagues are trying to remind us is that even if the rules initially appear in your favor, we can't expect courts to reach results that defy common sense. Can you dig your wells in such a way that you won't cause any damage? I suppose I might be able to, Fred replies, but that would cost a fortune and might spoil the deal altogether. Is that what you are advising? You'd better at least do that, adds the firm's best-dressed associate, whose parents oddly named him Iraq as well. I agree the issue is whether Fred can pump without paying for the damage. The rule in Texas, though, is that an owner is responsible for damage caused by land subsidence. Applying that rule means our earlier discussion of underground water is irrelevant. This leads me to the conclusion that because Fred knows he's going to cause the subsidence, he'll certainly be liable if he could prevent it easily, and might be liable even if there's no way to dig without causing subsidence. Carla now turns to you and says, so, where do you come out on all of this? Every instinct in your competitive body is telling you that you need to take sides. Are you with Iraq your friend, or Iraq the good dresser? Or what about Miss Policy? If this were Final Jeopardy, you'd either pick the right one or go home empty-handed. But Fred is not a game show host, and Karia doesn't want your vote, she wants your analysis. You might say something like the following. Fred, before we go any further, I'll spend a day in the library trying to discover if there is any case like yours decided in the Texas courts. But since no one here knows of one, I'll probably come up dry. What this means is that if you go ahead and dig, and damage does result, you are likely to be sued by the victims. After all, they will have suffered considerably, and are unlikely to accept that without a fight. You will have a strong legal argument that you should not have to pay. Many judges will see this as an open and shut case in which you have simply exercised your right to withdraw water from your own property. As you have heard in the discussion, Texas law recognizes that right. But as you also heard, Texas has a different rule that applies to land subsidence cases. These cases normally involve owners who remove soil from their land. But there's no logical reason why they might not be extended to cover withdrawals of water. If your neighbors push this argument, some judges will see them as mixing apples and oranges. But other judges may see a legitimate clash between two valid rules. That clash will be resolved through a combination of gut judgments and careful consideration of social policy. If you want, we can try to put percentages on our estimation of your chances of prevailing. Rough guesses today may give way slightly to more thoughtful judgments after some additional research. For now, however, it seems safe to say that there is a non-trivial risk. You'll have to pay even if you dig with the utmost care, and a substantial chance of liability if a court concludes you could have accomplished similar goals by digging more carefully. Carla says she's heard enough, adjourns the meeting, and asks you to stay behind with her and Fred so that the three of you can go to lunch. Hard cases make good exams. We're sure you can tell that our little story, based on the case of Friendswood Development Co. v. Smith Southwest Industries, 576 SW, 2D21 Tex, 1978, was carefully selected to show how even simple questions can lead to a range of conflicting approaches. In the terms we presented in Part I, this legal problem is one of competing domains. Lawyers often disagree about what percentage of problems in day-to-day practice actually raise such thorny issues. Certainly, there will be times when clients will walk in and ask questions like, "Will I have to pay income tax on money my employer gives me, even though it's not part of my regular salary?" All things being equal, a simple yes might suffice here, although further probing might allow you to suggest techniques like company-provided automobiles for business travel that might reduce your client's tax burden. But almost all lawyers agree that clients frequently present issues where the judicial result is in doubt, and a great deal of thought is necessary to consider how to proceed. And what's even more important, virtually all law professors agree that it's the thorny problems that make the best exam questions. Putting Part I directly into the context of exam preparation then allows you to see all our forks as answers to the following questions. Where do all those thorny issues come from? What is it about law that generates so much opportunity for argument, and thus requires law professors to train students to consider both sides of every question? Who put all those wicked witches into the wonderful land of laws? You should now have a better sense of why law is about issues as much as it is about rules. And so we will proceed in the rest of this part to discuss techniques for improving your ability to spot issues on your exams and to handle them well when you find them. We want to close this chapter, however, with a few more observations about the connection between the constructed world of the law school exam and the real world of the practicing lawyer. Return then to our story about groundwater. The easiest point to see is that the legal story begins not when Fred decides he wants to pump, but at the moment it occurs to him that his neighbors might be damaged and might seek legal redress. It's conflict like this, actual or potential, that is always the root of legal problems. As you read through many exam guides, ours included, you'll note recurring advice about how an important way to organize your answers is to pay careful attention to the various parties named or adverted to in the question. This is a useful technique to develop, but it's important not to forget where it comes from. Pairing one party against another to assess whether there are grounds for legal redress is not an artificial performance enhancement for exams, but a logical outgrowth of the nature of legal practice. Remembering that law begins with conflict is also a useful antidote to the overly formulaic approach to rules that we cautioned against in Part I. Fred's lawyers must start from the point that there are neighbors out there who may be harmed by what Fred wants to do. No rule Fred can cite, or law he can pull from a book, will make their loss or potential anger disappear. They may be able to hire their own laborers who will devote all their intellectual energy to figuring out some way to translate their actual injury into a legal cause of action. Our example is tailored so that the well-dressed Iraq is able to pull out the subsidence rule as a counter to the water rules. As we have seen, such rule conflicts often make good issues for exam analysis. They also show how sometimes the issue in a case is which of two bodies of law should be applied. an issue that might be lost if you are blindly following the Iraq method. Like our hero in the story, what you need to do on exams is move rapidly and aggressively in linking issue recognition to what your client wants to do. But even when rules aren't paired so neatly, the lavers for the neighbors are unlikely to give up without finding something in the law to support their case. Conflicts like that between Fred and the neighbors pit one person's right to do what he wants on his property against another's right to be secure in hers. Since American law values and protects both rights, it's only natural that the law will contain provisions that point in both directions. And the number of conflicting values we treasure, things like liberty, equality, free speech, fair trial, or efficiency due process, make conflicts in the law unavoidable and give law professors ample opportunity to invent problems that will pull you in both directions. Keeping in mind the human dimension of legal conflict will also help prevent you from getting stuck on only one issue. Notice that Fred comes to his lawyers wanting to know whether he'll have to pay if he pumps out the water. A blizzard of studying and cramming categories into your head may help you to recall that there's an issue of whether Fred's withdrawal of the groundwater was done negligently. And if you read back through our story, you'll see that this issue, as much as the one Fred originally posed, eventually became important to the discussion. But if you imagined Fred in a room with the injured neighbors, this issue would quickly leap out at you. When Fred says to the neighbors something like, "I made a good profit selling that water, and after all I only took water that was rightfully mine," you just know some neighbor will shoot back, "Yeah, but did you really have to pull the water out like that?" In sum, the vast panoply of disputes that form the core of law school exam questions are no more than a formalized representation of the variety of human conflicts that occur in our complex society. Think back over your own life and ask yourself how many serious conflicts you have had that could readily be resolved with a simple yes or no answer. That's all it takes to begin to understand why most law school exams are about getting to maybe.